Jeff Slauson here from 19 News Now at the 19 News Digital Desk. We're going to be bringing you to the sentencing of a woman who pled guilty in stealing parent-teacher organizational funds from Westwood Elementary School over a fairly long process here. In total, stole $25,000. That is the woman on your screen right now. That is Catherine Burry. She pled guilty to stealing these funds, was convicted of 2 counts of grand theft. As a part of the plea, she has agreed to pay almost $40,000. The total is $39,899 in restitution. That back to the Westwood Elementary Parent-Teacher Organization that is part of the West Geauga Local School District. Sentencing today. The story behind this is actually quite fascinating here. So essentially what happened is she was accused initially of stealing $25,000 of the parent-teacher organization funds for quote-unquote her own personal benefit. Now initially when this started to come out and the information started to become a little bit more known, the PTO and president started to look at some of the financing. They found that the corporate bank account was significantly lower than it was supposed to be. Then, the president found Burry used the funds to pay herself, her own business, it says hipsters, and other third parties without authorization to conceal fraudulent activities. So basically, she was doing this willy-nilly and did not cover her tracks very well. She was immediately removed from the accounts, and that's ultimately when they brought this to the attention of the authorities. So there were civil counts on this that was related to fraud, theft, breach of fiduciary duties, conversion, adjustment riches, punitive damages, etc., things like that. And this is kind of that initial part of it. But again, $25,000 is what she was accused of taking, and then ultimately what she pled guilty to taking as well. So the guilty plea was 2 counts of grand theft in this. So not all of those counts ended up being pled guilty to. That's pretty common. But she is ordered to pay as part of it as well. So the sentencing, in addition to what we learned today, ordered to pay $39,899 back to the Westwood Elementary PTO, that is at the Westwood Elementary School as a part of West Geauga Local Schools. So already had to pay back what she took and then some, probably related to attorney fees, finding fees, things like that. So basically had to pay almost double of what she took, and then now gets the sentencing as well. Again, pled guilty to 2 counts of grand theft. The judge is walking in now as you see everybody getting up. Let's take you now to the sentencing.
All right, it's Friday, February 28th, 2025. I'm Judge Paschke. We're on the record on case number 24C-143, matter known as State of Ohio versus Catherine E. Burry. Ms. Burry is present in the courtroom today. She's represented by Attorney Mark Gardner, Mr. Flays, the Geauga County Prosecutor, as well as Assistant Geauga County Prosecutor Christian Bondra are also present in the court. And we have Ms. Bokar with us via video from our court's probation department. Mr. Flays, will you introduce the case, please?
Thank you, Your Honor. The defendant was indicted by the Geauga County Grand Jury in an indictment filed on October 29th of 2024 as a 3-count indictment alleging money laundering, felony of the 3rd degree, grand theft, a felony of the 4th degree, telecommunications fraud, a felony of the 3rd degree. After much discussion, the defendant did enter a change of plea, and on January 7th of this year pled guilty to count 2 of the indictment, grand theft, a felony of the 4th degree. As part of that plea agreement, she agreed to pay restitution in the amount of $39,899.10, and that has been paid to the PTO representatives that are here and their counsel today by certified funds. And we are here for sentencing. Thank you.
All right, thank you. Mr. Gardner, do you or your client have any reason why this matter should not proceed to sentencing at this time?
No, Your Honor.
All right, and have you had an opportunity to review the pre-sentence investigation?
Yes, Your Honor.
Do you or your client have any changes or modifications that you'd like to make as far as the pre-sentence investigation is concerned?
No, Your Honor.
All right, then you may present what you have to present regarding sentencing.
Judge, the pre-sentence report actually was very thorough, very complete. It portrays a 43-year-old married woman with 2 children who started a business and the business wasn't working out as well as it should. And due to her position, she had access to the PTO's money. In small, tiny increments, she was taking the money, trying to keep her business afloat. And one thing led to another, it got out of hand. And she ended up taking money from the PTO, did not belong to her. She acknowledges that. When you look at her as a whole person, 43 years old, the worst thing that she's ever done in her life is she has a speeding ticket. She's not character flawed. She's not some sociopath or psychopath that goes out of her way to harm people. She's not rebelling against society. She's not discarding other people. Fact of the matter is, well, she worked at the PTO. She was buying things for the PTO and taking care of a lot of different things, paying various bills for them at the same time that she was taking money for herself. She's ashamed of it. Her 10-year-old son wanted to find a picture of her mother and father so that he could put it on his computer home screen, and when he ran a search, he came upon all of this that's happening with Westwood Elementary. And that was ultimately how her 10-year-old son found out that his mother is being charged with these serious offenses. This whole experience has been a shock to her system. Like I said, somebody who's never, ever been in trouble before in her life. In fact, from the pre-sentence report, it actually shows that she was the victim of herself of something that was very serious while she attended Purdue University. She understands the pain that she's caused. She's lost all the people that were her friends, literally, all the people that were her friends tied to the school that her children go to. They don't talk to her, they don't see her. Delivering her children to the school where the children actually are being teased about their mother, what she did. This has upended her life in a way that she never, ever could have imagined. She is full of shame, she's full of embarrassment over her actions. She understands what she did was completely wrong, and she can assure the court that never, ever again will she ever darken a courtroom doorway for anything that relates to criminal behavior. This is truly a person who is good to her core and got caught up going down the road of trying to save a business, and things got out of hand for her. And she's paying, having paid restitution, and she already knows from the civil side of things that there's going to be treble damages that will be coming out of this. So she's paid through the nose, paid from abandonment of friends, paid from the embarrassment and shame of dealing with this with her children, her husband, her parents who are in the courtroom also. She has suffered quite a bit being an ordinary, normal person. We strongly believe that there, of course, will be consequences, but we're asking the court to be reasonable and show mercy in the consequences that the court imposes. That's why we're asking the court to impose a sentence of no more than 30 days in the Geauga County Safety Center. We truly believe that will be plenty enough as punishment for her. It's not even going to be a wake-up call for her because she's already woken up out of this entire situation. And she has, as I said, more things to go through on the civil side. But that's plenty of punishment for somebody who has never, ever committed crimes, darkened any courtroom for anything that was wrong. We ask the court to take these matters into consideration. Thank you, Your Honor. My client has wrote out a short statement she'd like to read to the court.
All right, thank you. Ms. Burry, I'm going to ask you to stand up, and now's your opportunity.
Thank you, Your Honor. I fully accept responsibility for my wrongdoing. I'm appalled by my actions and feel deep sense of shame. To the community, the school, the parents and students, you were undeserving of my betrayal. My husband, children, family, and friends should not have to bear the shame, embarrassment, and discomfort that my regrettable decisions have brought upon them. I recognize that it was unfair to subject you all to this situation. Struggling to manage a failing business without asking for help was not only misguided, but also very immature. I alone made these choices, and I genuinely regret each one. Thank you.
All right. Anything else, Mr. Gardner?
No, Your Honor.
All right. Mr. Flais?
Thank you, Your Honor. And the victims weren't going to present anything in court today, but they did present a very detailed victim impact statement that was submitted as part of the pre-sentence investigation.
I did receive that, and I have
Okay.
reviewed it.
Thank you. The state is recommending 2 years community control sanctions with a 90-day sentence in the Geauga County Jail. And here's the reasons why. The state acknowledges the defendant has no record other than this, has led a law-abiding life. The recidivism factors do not apply here. The state is fully aware of that. And very importantly, restitution was paid for the stolen funds. Again, that shouldn't get you out of all consequences, but that is a mitigating factor that weighs heavily here because this elementary school organization, these kids were out this money and they were made whole, at least from the monetary standpoint, but I'll talk more about the other damage that was done that I don't think they've been made whole from. But those factors do mitigate the conduct, and there has been genuine remorse shown. So, but for those things, the state would be here asking for a prison sentence, and we're not asking for a prison sentence. We're asking for the 90 days because we do recognize that those statutory factors do weigh against that. But the 90 days is appropriate because when you look at the conduct here, this was essentially stealing from children. I mean, stealing the book fair money from the elementary school, community events, elementary school events, enrichment activities for little kids in the school district, and you're pocketing thousands of dollars of this money meant for these kids, to help these kids to enrich their elementary school experience. We've all had elementary school kids, we've all been done at the book fair. These are important elements to these little kids' education, and to take almost $40,000 of those funds is really unconscionable. And I do have to push back a little bit. There's a narrative of, hey, she had this failing business and she took the money to prop up the failing business. She did have a failing business. It was lucrative at one point. We've looked at all the financial records. The business was struggling, and some of this money was used for the business, but the vast majority of the stolen money was not used for the business. She did pay some sales tax money she owed to the state. She installed a brand new floor in the space. I don't know that was an essential item for the failing of the business. So she did spend thousands of dollars of the stolen funds on the business, but the majority of the funds were not spent on the business. The majority of the funds were spent maintaining her lifestyle. And it's frustrating, and I don't want the court to get a picture of, hey, this is somebody that got in over their head with the business, they stole the money. Multiple ski trips to Peak and Peak with her family. Just for an example, the 1 month she deposited $7,000 into her account in stolen funds, she went to the ML Tavern, which is an upscale restaurant in Moreland Hills, spent $536.63 on a dinner at ML. I don't go to ML. Shopping at Nordstrom, Athleta, J. Crew. I'm looking at these debit card purchases, these same months that she's depositing the stolen funds, and she's up in Chautauqua, New York, on trips. So that's not supporting your business. That's maintaining a lifestyle that a lot of people can't enjoy and using these stolen funds from the elementary school to do it. It's pretty outrageous conduct in the state's opinion.
And the other thing is, we have cases where somebody makes a mistake, and we hold them accountable for the mistake. They get in a car when they shouldn't, and they hurt somebody, right? They made a mistake, and there's consequences there. This is a course of conduct. This happened over, months. And then the reason it was discovered was, she wanted to stay as the treasurer. She didn't want to hand over the books to the successor, right? Because she knew that this would probably be discovered. And so you have a course of conduct, and that is where this is different than even some of our other cases where somebody makes a lapse of judgment and something bad happens. We send those people to jail all the time. This is in some ways worse because it is that course of conduct. The other element of this, and I won't spend a lot of time on it because really this is one of the better victim impact statements I think I've ever seen in my 13 years of being prosecutor here. It was articulated extremely well, but I know that we have had these embezzlements from these community organizations, these charitable organizations. I've had them with the court. And what's an aggravating factor there is, A, you're in a position of trust. She abused a position of trust as the treasurer of this organization to line her own pockets. That's a problem. And when you look at the impact statement, much better than I could put into words, just the impact these events have on organizations. You lose the trust of the community. You lose donations. You lose volunteers. I mean, these women in the back barely were able to keep this afloat. And thankfully they did, because we all know how much the PTO helps. I've got an elementary school student right now. I mean, these are great activities, great events. They really help these kids. But, you look at, now they discover this, they have to get a lawyer, they're going through the books. Instead of spending their time helping the kids, they're spending their time on damage control, trying to keep the organization afloat, and they're spending countless hours trying to get to the bottom of the theft instead of doing what they volunteered to do, which was to help the kids at the elementary school. So, you have to look at the damage to those left behind and the damage to these folks here and the fallout from what she did, which they're still recovering from when you read the victim impact statement. So, again, the state understands the mitigation, the state understands the statutory factors weighing in the defendant's favor because she doesn't have a criminal record. But the conduct really is borderline outrageous, and it is warranting a lengthy jail sentence, and so the state is recommending 90 days in jail as part of a 2-year community control sanction with the standard conditions. Thank you.
All right, thank you. The court has reviewed the pre-sentence investigation. The court has reviewed the letter or the victim statement that was attached with the pre-sentence investigation. I've also received a document entitled Receipt of Restitution that is signed by the attorney for the victims, acknowledging that Westwood PTO did receive a cashier's check in the amount of $39,899.10 for total restitution in this case. I have also reviewed the plea agreement, and I've listened to the statements that have been made here in court today, and I have reviewed the entire record in this case. I have considered the purposes and principles of felony sentencing under Revised Code 2929.11, as well as the seriousness and recidivism factors under Revised Code 2929.12, including the seriousness of Ms. Burry's conduct, the factors which make her conduct more serious, as well as the factors which make her conduct less serious. I did listen to the comments the comments that were made here today. And Ms. Burry, I do recognize that you have no criminal record coming into this sentencing here today. I did hear what you and your attorney had to say, and again, recognize also that you've been cooperative through the entire course of this case, as well as that you have made full restitution pursuant to the agreement. I do also, though, recognize that there were a lot of victims in this case, the elementary school students, the teachers, the parents, as well as the other PTO members. Again, having read the statement, and I am going to address the victims real briefly here, I'm sorry to you that you've had to endure this. I know that as people who have volunteered to help out at your children's school, you didn't expect to be sitting here in this courtroom, and that you didn't expect to have to go through everything you've gone through. I would have liked to have seen your time and efforts going instead toward making the children's experience a better experience, which I think was your purpose in volunteering and being active in the PTO. And I'm sorry for you that you've had to spend the time that you had to spend, first of all, tracking this down and figuring all of this out. And again, I read your statement about how a lot of the beginning of the year activities either weren't able to happen or had to be covered by other people, about the issues with the book fair, about a number of those other things that you do. And again, like I said, I understand, and that when parents generally sign up to help PTO, that's what their purpose is. So the fact that it's come to this is concerning and clearly disappointing. And I also did hear what Mr. Flays had to say, Ms. Burry, about the fact that this wasn't a 1 or 2 time thing. This was a course of conduct over a period of 3 years. So taking all of those things into account, I am sentencing you to a term of 2 years of community control. I am going to follow the state's recommendation and order 90 days of that be served in the Geauga County Jail. You're also ordered to obtain full-time employment. You're also ordered to continue with mental health counseling and follow all of the recommendations, including any type of assessments that are recommended as far as mental health. I'm also going to give you our standard community control conditions. You're ordered to obey the rules and regulations of community control. You're ordered to abide by the law. You're ordered not to leave the state of Ohio without permission of the court or the court's probation department. You're ordered not to possess or consume any controlled substances or alcohol without a valid prescription. You're ordered not to frequent any bars or taverns or establishments whose primary source of income is the sale of alcohol. There is a $300 fee to be supervised by our probation department. That would be your responsibility. And you're ordered to pay the court costs in this case. I'm going to go over that at the end. If you violate the terms of your community control sanctions, violate the law, or leave the state of Ohio without permission from your probation officer, the court may extend the period of supervision, may impose a more restrictive sanction, or may impose a prison term. The prison term reserved is 18 months. Since there is a reserved prison term, I need to go over post-release control with you. You may be subject to a term of up to 2 years of post-release control under Revised Code 2967.28. If this period of post-release control is imposed following your release from prison, and if you violate the conditions of that supervision, the parole board may impose a prison term as part of the sentence of up to 1/2 of your stated prison term. If while on post-release control you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term, an additional consecutive prison term of 1 year, or what time remains on your post-release control term may be added as an additional penalty. You're also instructed that most prison inmates are eligible to earn days of credit against their prison sentences for participation in programs. Said days of credit, if you're eligible to earn them, are not automatically awarded, but must be earned in the manner specified in the statute, which is 2929.14 and 2929.19. It looks like there is no credit for time served. It doesn't look like there's been any time served yet in this case. And then, Mr. Flays, are you asking the court to dismiss counts 1 and 3?
We are, Your Honor. The state's also requesting, it's my understanding her children no longer attend. They've moved on from Westwood Elementary. So the state is asking for a no contact order for Westwood Elementary School. And then we'd also ask the court to order restitution.
And acknowledge the payment?
And acknowledge the payment. The amount was, sorry.
I've got the amount here.
Thank you.
Mr. Gardner, I'm going to give you an opportunity to be heard regarding the no contact order. Would you like to be heard regarding that?
If the court is speaking about her having no contact, no objection.
Okay. Then I'm going to order, Ms. Burry, that you have no contact with Westwood Elementary School or the Westwood Elementary PTO and its officers as part of your conditions of community control. As far as the restitution is concerned, I do order that you pay restitution in the amount of $39,899.10 and acknowledge also then the receipt that has been provided. So we'll address that. And I think we addressed the issue. We're going to dismiss counts 1 and 3. Then, Ms. Burry, you are responsible for the court costs in this case. If you fail to pay any financial penalty or cost, the court may order you to perform up to 40 hours a month of community service until the court is satisfied that you're in compliance with an approved payment schedule. If you perform community service on this basis, your financial penalty or cost will be reduced to the extent of the federal minimum wage. The court isn't ordering any payment plan or community service at this time, but renders judgment against you for the costs for which execution may issue. All right, I believe that covers what I needed to cover. Mr. Flays, anything else that you'd like to address at this time?
No, thank you, Your Honor.
All right.
Your Honor?
Yes.
The out date for the sentence?
Oh,
Okay.
have we calculated an out date?
Your Honor, Mr. Bonder did he calculated May 29th, 2025.
Your Honor,
It looks like that we've got something. I'm just going to pause for a moment while this is discussed, but I will give you a chance to be heard. Anything else there?
Oh, I'm sorry, Your Honor. The counsel for the victims did want an exception to the no contact order, that there be an exception on the record for contact related to the ongoing civil litigation that was discussed earlier.
Okay. Any objection to that, Mr. Gardner?
no.
Okay, so Ms. Burry, and that seems appropriate to me. Certainly if there's a deposition or a hearing or something like that, you are permitted to have contact with the victims for purposes of defending the civil litigation. All right, Mr. Gardner, go
Your
ahead.
Honor, understanding the court's sentence, we're requesting that Ms. Burry be allowed to report to jail April 1st. Thank you.
All right, thank you. And Mr. Gardner, it's not my policy to allow late reporting, so I'm going to deny that request and order an out date. Then, Ms. Burry, you will be released from the jail on May 29th, 2025. All right, thank you, everyone. We're adjourned.
All right, so this showing that in this case the crime absolutely does pay. That woman there will be headed to jail for 90 days as a result of stealing money from the parent-teacher organization at an elementary school in Geauga County. As you see, noticeably upset now knowing that she is about to walk into the Geauga County Jail for the next 90 days. Again, this case comes from a 2024 incident where that woman that you saw on your screen there, Catherine Burry, stole $25,000 from the parent-teacher organization for Westwood Elementary School. She then used that to pay friends, to pay herself. According to her lawyer, she had a struggling business that she was looking to pay money on and use the funds for it. The president of the PTO had noticed that there were some issues with the books, ultimately figured out it was Burry, reported it, and then they were able to bring the charges. Again, she did plead guilty to this. However, just because she pled guilty, that didn't mean that she was going to be able to escape the crime. Has to pay back about $40,000. And then in addition to that, now goes to jail for 90 days and then 2 years of community control. All right, much more on this coming up tonight. 19 News, 3 o'clock newscast continues over on CBS. So we'll see you there.
19 News, now streaming on Samsung Smart TV. Search for channel 1035.